Hello, my name is Steve Darty, and I'm the founding attorney for a law firm called Montana Elder Law. And so we do estate planning, elder law, and estate administration, or helping families when they lose a loved one. And I teach a workshop, a very detailed workshop across the state. I have done so now for about 8 years. And that workshop's 2 to 3 hours. And so what I wanted to do today is to present just a summary, hit the key points of what we cover there, and kind of maybe cut to the chase to answer some questions. So, probably the number one question I get from a lot of my clients is, Steve, is there anything that we can do to save our home and life savings from nursing home costs? And I say, yes, there is, but it's got to be done right. If done incorrectly, it can be worse than doing nothing at all, because we have some basic statutory protections. But if we don't necessarily thread the needle in terms of the legal work we're doing, or if someone tries to do it themselves, then oftentimes you can end up worse off than having done nothing at all. And we help clients two ways. The first is what we call proactive planning. And so a proactive plan client is someone who calls up, says, Steve, I'd like to protect my home from future nursing home costs. My spouse and I are both healthy, but we know we're capable of developing something more serious, and we just want to be proactive and protect. Okay, so that's what we're going to talk about today. Now, there's a second way we help people, and that's when a loved one is already in a long-term care facility. And so maybe I'll address that in another webinar. But this workshop is going to be for people who are healthy, but maybe want to create an alternative form of long-term care insurance. God forbid you develop an illness that requires you to leave the home and require long-term care. And what is important to understand is every law we have that is passed is designed to support, promote some kind of public policy. And we have a lot of public policy, such as we want to discourage or we want to try to prevent spousal impoverishment. Okay, so that's where one spouse falls ill, and through no fault of their own, the well spouse who's still in the house ends up having to sell the house to pay for the care of the sick spouse, and then the well spouse has to move in with the kids, which a horrible crisis in and of itself. So we want to avoid that, right? And there's laws that allow us to do so, but also for single individuals, we have laws designed to promote a public policy, such as we want to take care of our senior population, our disabled population, and so on. But if you don't know the laws, you can't use them for your benefit. So we're just going to kind of touch on the primary strategy that we use to help clients build a moat around their castle, so to speak, because your single greatest financial risk, it's not getting sued, it's not getting scammed, it's just aging and needing to leave the home for assisted living, skilled nursing care. And just so you'll know, the average cost in Montana currently for assisted living is about $55,000 a year. So, almost $5,000 a month, nearly. Skilled nursing care, which is what we typically think about in terms of full-blown nursing home care, that's over $100,000 now, and those are average numbers. Okay, I have one client who's paying $15,000 a month, so it just kind of depends. So if you kind of look at, if you had to do that for 2, 3, 5 years, you can quickly understand why that's your single greatest financial risk. And so let's talk about how we prevent that. I guess I'd like to start by saying, I hear this question or I hear this statement a lot. Steve, I put my house in my child's name and I added my child to my bank accounts. Didn't I do good? Why would someone do that? Now, first of all, if you have done that, maybe that was an appropriate action. Okay, so I'm not necessarily saying you did anything wrong, but let's analyze that, unpack that. Let's kind of figure out what the consequences are. So there's two reasons someone would do that. Number one, if you put your home in a child's name, when you pass away, there will be no probate, most likely. Normally what pulls us into probate is the real estate, okay? Any home that's owned by an individual, when that person passes, we have to transfer that to the heir. And if we haven't done any pre-planning to address that, then we're going to have to go to court through a process called probate to get the court to approve a new deed transferring. So we want to avoid that. I tell all of my clients, Hey, we want to avoid ever having to go to the courthouse. So no probate, no guardianship hearings, conservatorship hearings, nothing like that. You want to keep things out of the courthouse, do them privately. And I can promise you, if you do that, you'll, as we say, you'll have your ducks in a row, which means the administration of your estate will go very smoothly and the costs will be very low. See, in Montana, probate, what is probate? Well, that's just the state of Montana's process for closing the books on us when we die. They want to make sure that all expenses and taxes have been paid off before the assets pass to the heirs. Well, that sounds like a good idea, and it is, but going through probate is a clunky process. An uncontested probate in Montana, they'll average somewhere between 12 and 18 months. If you hire a law firm to do it on your behalf, you're probably looking at $5,000, maybe a lot more, depending on the size of the estate, complexity of the estate, and how well everybody gets along. So if we can avoid that, we want to, but it's not just the cost in dollars. I tell everybody, it's the cost in time. Probate delays emotional closure. Okay, so when we're sitting around for 1 to 2 years waiting for the estate to settle, it just kind of extends the grieving process. And some of you have been through that. You know exactly what I'm talking about. So what we want to try to do is get that estate administered in less than a month, maybe a few days or weeks, right? So that's the goal. So that's the first reason someone would put their home in their child's name, is to get it out to avoid probate. Now, the second reason, and we're going to talk about this today, is that some of you may have heard of what's called the Medicaid 5-year look-back period. Well, what is that? Well, that's Medicaid's attempt at preventing fraud. So they don't want Bill Gates on Monday to take his fortune, put it in his children's name, and then on Tuesday or Wednesday go into long-term care, apply for Medicaid, and have Medicaid pay for all of his care for the remainder of their life. And so what the 5-year look-back period is, that's Medicaid's attempt to prevent fraud such as that. So Medicaid says any gift you made in the last 5 years is going to be a countable asset, okay? So if you gave a child or grandchild, whatever, say $10,000 2 years ago for whatever reason, that will be treated just as the same as if it was sitting in your savings account. Now, if you leave this workshop with one thing, this is what I want you to understand. Medicaid will pay for all of your long-term care once you have less than $2,000 of countable assets. And this is what I want you to know. I did not say total assets. Okay, so there's countable assets and there's non-countable assets. And what we as elder law attorneys do is we take your countable assets and legally convert them into non-countable assets. Okay, so we just got to know what the laws are, and we can do this legally. There's no reason to hide assets, anything like that. And if we can position ourselves, so God forbid we need that long-term care one day, our countable assets will be very low, including our home. And so if we did have to go to long-term care, instead of going broke, then having someone in the nursing home fill out a Medicaid application for the remainder of your care, we want to go ahead and pre-position yourself so in that event, you're going to go ahead and qualify. Or very quickly, you'll have what's called a spin down. And we want to minimize what your spin down is. So we're kind of building a floor to how much you could lose if you become seriously ill. So back to the person who, and typically this is the fact pattern. It'll be a single lady with one child, and the child's a daughter, and they're very close. I see it all of the time. And so they'll put the house in the kid's name. They'll also add the child to the bank accounts. Why? So they can sign checks, right? And they can, when upon that person's passing, then it'll go 100% to the child. See, when you add someone to your account, if there's just two of you, you just gave 50% of your account to whoever you added to the account. So there's some downsides to that, and I want to caution you against doing such. But back to that second reason, if mom puts her home in her daughter's name, let's say, and we count, that starts a 5-year clock ticking, 60 months, clocks begins to tick. 5 years from now, so let's say that's done on January 1st, 2024. Then January 1st, 2029, that's your finish line. You cross that finish line, that house is still in your daughter's name, then that becomes a non-countable asset because of the Medicaid 5-year look-back period. Again, any gift you made in the last 5 years is countable asset, but if it's been more than 5 years, it's not countable. That's the second reason, okay? But by the way, how many countable assets can you have? $2,000. That's it. What assets are countable today? Pretty much everything you got is countable. But if you took that home and put it in your daughter's name after 5 years, that would come off the countable list and go into the non-countable list. Now, there's downsides to doing this. Number one, if you put your home in your child's name, and after you pass away, hopefully a long time down the road, if child or children turn around and sell that home, they're going to get crushed in what we call capital gains taxes. And I don't want to get too far out in the tax weeds today, but this is what I want you to understand. There's a big difference tax-wise from a gift and an inheritance. And we want our children to inherit. We don't want to give them things while we're alive unless there's an overriding reason, and sometimes there is. But from a tax perspective, let me kind of go through this. So when you sell an asset that's gone up in value, the accountant's going to want to know, what did you pay for it? What you paid for that asset. Let's say your home. Let's say you bought it 20 years ago, you paid $200,000 for it. That's what the accountant's going to refer to as your cost basis. Now, 20 years later, you sell it for $400,000. You have a $200,000 capital gain. You got to pay capital gains taxes on that. Now, getting a little further out in the weeds, if you have lived in your home for 2 of the last 5 years, and you sell that home, you get what's called a 121 exclusion on your capital gains taxes. And Section 121 of the Internal Revenue Code says if you lived in your home for 2 of the last 5 years and you sell that house, the first $250,000 of gain per owner is excluded. So back to this scenario, if an individual buys a home for $200,000 and they later sell it for $400,000, that's a $200,000 capital gain, right? Well, if they've lived there for 2 of the last 5 years, they get a $250 exclusion, meaning they'll pay nothing in capital gains taxes. For say a married couple, you each get the $250. So if you're both on the house, on the title to the home, then that property has to go up $500,000 in appreciated capital gain before a capital gains tax is triggered. So that's the reason the vast majority of people, when you sell your primary residence, you don't have to pay any taxes. All right, laying that foundation to explain this, when you give someone a gift, you give them your cost basis. So if you add your daughter to your name, her name to your title, and she's now the owner, you gave her your $200,000 cost basis in this scenario. And so let's say that many years down the road, so if you paid $200,000 for your home and you pass away and you leave it to your daughter, and let's say that she sells it for $400,000, the accountant's going to want to know, what did you pay for your home? And the child will tell the accountant, I didn't buy the home. My mom put it in my name before I passed away. Well, the accountant has to use your cost basis to calculate whether or not there's a capital gain. And guess what your daughter does not get? The 121 exclusion. Why? Because she didn't live in the house for 2 of the last 5 years. Maybe she did, but most times that's not the case. And so let's say that it's a $200,000 capital gain, and I'm going to give her a low capital gains tax rate of 25%. So what that means, she sells that house, she's going to have to write a check for at least $50,000 in capital gains taxes. So we don't want that. Now, with an inheritance, if you pass away and your daughter or child or children, they inherit that home through a will or a trust, and then you pass away, they inherit it, now they turn around and sell the house, do they owe capital gains tax? And the answer is no. And here's the reason. If the child goes to sell it and the accountant says, well, what did you pay for the property? And they tell the accountant, well, we didn't pay for it, we inherited that. Now the accountant's going to give them a cost basis of date of death value, and it's called getting a step up in basis. So upon your passing, if that home is worth $400,000, that will become their basis. So they turn around and sell it for $400,000. $400,000 minus $400,000 is zero. There'll be zero capital gains taxes. So the first reason that it's a bad idea to put your home in your child's names is capital gains taxes upon your passing if it's ever sold. And if it's 30 years before you die, then it's going to be a really big capital gain. We all know what homes have done so far as appreciation in Montana over just the last decade. So we want our kids to inherit our assets that have gone up in value. But I don't typically let the tax tail wag the estate planning dog. Here's the bigger reason. If you put that house in your daughter's name, let's say, and 5 years later, or 5 days later, she's in a car wreck, let's say. She's driving down the road, she gets a text, and she looks up, and she takes out a van full of trial lawyers. Then she's going to get sued, and they're going to go after every asset in her name. Guess what's in her name? Your home. Bad idea. So unless there's an overriding reason, we never really want to put our assets in anyone else's name because we lose control of the liability. Okay? Same thing could apply if she gets divorced. My point is, if you put your home in your child's name and they get sued or divorced, you could be homeless. So bad idea. The second bad idea is if they ever sell it after you have passed away, they're going to get hit really, really hard in capital gains taxes. So back in the 90s, elder law attorneys, we realized that this was a problem. So what did we do? We created a very specific type of trust. Lawyers refer to it as a Medicaid Asset Protection Trust. Big name. We just talked to our clients, call it an asset protection trust. And what we've done with the Medicaid Asset Protection Trust is we've looked at the reason that you would why would you put your home, life savings, whatever in a child's name, and then we look at the downsides, and then we create this specific type of trust to avoid that. Okay, so this specific type of trust, how does it work? If I create this trust, and instead of putting it in your child's name, you put the house in this specific type of trust, it starts your 5-year clock ticking, just as it will with a child. Okay, so this is a 5-year plan. Proactive planning is a 5-year plan. We put it in, let's say again, January 1, 2024, then January 1, 2029, that's your finish line. You pass that line, you'll never, your house will convert from accountable to a non-countable asset, and you'll never lose the home to long-term care costs. So pretty straightforward. Also, when you pass away, your child will inherit it. So it'll come out of the trust, go into their name. They get the step up in basis, and if they ever want to sell the asset, then there's no capital gains taxes. And this is a huge, huge thing when I'm dealing with ranchers and farmers. And so instead of it being $200,000, it might be a $2 million fourth generation farm. Okay, so it's a huge, huge thing. And really what we're talking about is just an alternative form of long-term care insurance. It just takes 5 years. So it's not a magic wand, too good to be true scenario. It does take 5 years. Now, if I have a client, a family calls us and we don't have 5 years, right? Maybe the loved one's already in the long-term care facility, or we know that that's in the very near future. I'm not going to do the proactive plan. We have a process called crisis planning, and we can still save a considerable amount of the assets. We do that every day. But that is a little too long for a small mini workshop online. But what I'm going to do at the end of this video is there's going to be a link. And if you click on that link, it'll take you to the opportunity to request a call from someone in our office. And if you've watched this workshop, we're going to give you a free 30-minute consult. It can be done in person or over the phone. And if you have a loved one that's already in long-term care or facing that in the near future, just give us a call. We'll do a free 30-minute consult, and we'll give you a basic idea of what your options are and how many assets we can save. But back to this workshop, I really want to talk to the healthy people that are just concerned that hopefully we're never going to leave the home, but the unimaginable could occur. So we want to protect against that. Now, I want to talk about trust real quick because trust can be a little intimidating if you have no experience working with them. Folks, all a trust is a will substitute. That's how it's taught in law school. A trust is a will substitute. It does the same thing a will does. It's just designed to be administered privately outside the courthouse. Okay, so when you got a trust-based estate plan, there's typically no probate. Okay, which is an awesome thing. We get our ducks in a row. We settle some of our trust estates in just a matter of a few weeks, sometimes even a lot quicker. But what is important for you to understand is there's all kinds of different trusts. Most people don't realize that. A lot of lawyers don't realize that. And so all a legal document is a tool. All right, what is the job? That'll dictate the legal document that we're going to use. If is it a lease? Is it a divorce petition? Are we creating a will? We're trying to create a trust. What we got to do is figure out what is the job, and that tells us what tool to use. Well, the same thing goes with trust. I've done all kinds of different types of trust. I've done inheritance trust, pet trust, gun trust, gifting trust, estate tax avoidance trust, revocable living trust, blended family, revocable living trust, on and on and on, and of course, Medicaid asset protection trust. And the reason this is important, it kind of goes back to when I said you can protect your home and life savings from long-term care costs, but if it's not done correctly, it can be worse than doing nothing at all. If you do nothing at all, we always have the crisis planning strategies to come in and save what we can. But let me share with you a story of a client that we helped last year that they had heard. It was a farmer, third generation farm, and the farm was worth about $3 million. The families were not necessarily wealthy. They were what we call land rich and cash poor. And the farmer had heard a decade or so ago that you could put your home in a trust, and after 5 years, that becomes a non-countable if you go into a nursing home. And so this is what this farmer did. He hired a lawyer, and it was just the family lawyer, and the family created this trust, and sure enough, it was 7 years later, so it was beyond that 5-year period. This farmer falls ill. They have to place into a long-term care facility over in Billings, and they applied for Medicaid to pay for the care, and they were denied. And so the family called me because the lawyer that they had worked with, that lawyer had passed away. And so they called our firm. Someone had told them that we do this kind of thing. And so when I was speaking with the family, I let them know, well, we've helped a lot of families who've already been denied. So I said, let's just, when you're doing any kind of government application, particularly to Medicaid, you've got to dot every I and cross every T, and you can't put a round peg in a square hole. So I just wanted to take a look, thought maybe they missed something on their application. Well, they sent me the denial letter. They sent us a copy of the trust to review. Well, I looked at the denial letter, and it was very straightforward. And then I looked at the trust. In the very first paragraph, it said, this revocable living trust. Folks, I'm here to tell you, a revocable living trust, which is the most common type of a trust, it's probably 80% of the trust in the United States. A revocable living trust provides no protection from long-term care costs. A Medicaid asset protection trust, very, very, very specific. Very, very, very few lawyers will even touch it. Okay, so if you're talking to a lawyer, you want to ask them, how many Medicaid asset protection trusts have you drafted, and did they work? Okay, so it's a very, very specific type of trust. Now back to that family. So they were denied, and for legitimate reasons. They didn't have the right kind of trust. What did we do? We fortunately, just without going into too many details, there were some factors with the family ownership of that farm that allow us to do a couple of things. And we were able to use our crisis planning strategies, and we saved that farm for that family. And that client is now in long-term care, doing fairly well, but is being paid by Medicaid. They did not have to sell the farm. And I can only imagine what they would have owed in capital gains taxes if they had sold that farm, probably hundreds of thousands of dollars. So we help families all of the time, and particularly for agricultural families, because that can be a very large asset, and typically one we want to keep in the family. And I can, just so you'll know that this is not just all legal theory and business to me, I will share with you a personal story. My father's mother, my paternal grandmother, she was a farmer, and she was widowed in her 30s. She never remarried. And she had a lot of illnesses along the way, including cancer. But being a tough farming lady, she just kept licking everything that came her way. Well, the one thing she could not overcome was when she was 75, 76, my grandmother was diagnosed with Alzheimer's disease. And after a period of time, we had to find her 24/7 care. So the family placed my grandmother in a long-term care facility, and never really expected her to thrive there because she had those underlying conditions, including the cancer, but she had also lived in that home for over 40 years. So unfortunately, the expectation was not that she would have a long life expectancy once she went into the nursing home. But my grandmother continued to surprise everyone, and my grandmother passed away almost 10 years to the day of going into the nursing home. And when she passed away, again, like a lot of farmers and ranchers, she was land rich and cash poor. So the only asset that the family had to pay for her care was selling off parcels of the farm. Well, what happened when they sold off parcels of the farm? Capital gains taxes. And when my grandmother passed away, that big farm was a house and 20 acres. That was all that's left. Okay, so I get this personally, and I just absolutely love working with families here in Montana to avoid that. And it is avoidable. It's very easy to do. It's just got to be done in a very specific type of way. So if this makes some sense or stirs some questions you have, you can click on the link below, and what will happen is one of the assistants in our office will give you a call, and we'll schedule a free 30-minute phone call. We'll be with one of the attorneys in my office. And so on that phone call, you can explain, hey, this is what's going on. We have some questions. You know, how would this affect our life? First of all, it won't affect your life. You put your home in a trust like this, you can still sell it, you can move it. It's just no longer in your name. That's the whole point. Get it out of your name for 5 years, right? But if you're going to have questions, because it's a new concept to most people, and on this phone call, you can say, all right, well, what is entailed? How much will it cost? Okay, and in terms of what it will cost, it varies, right? But my firm, we quit doing billable hours a decade ago. We do flat fees. So whether it's just creating a simple will or a Medicaid asset protection trust, we work with a fixed price fee schedule. So no client hires us until we tell them, all right, this is our recommendation and this is what it will cost. So on that phone call, we'll probably be able to tell you what it would cost and answer that, given what the size of your family, your estate, what we're doing, how much work is entailed. By the way, the only thing that we ever charge billable hours on is probate. Who knows how long that's going to take. So it's just another testament to why we want to avoid probate. We have no way to calculate the amount of legal hours. So thanks for tuning in today. Some of you have probably come to my live workshop, so this is a recap. But what I wanted to do is get something online that was very brief, kind of a summary, and hit the main points. One thing for those of you who might be interested in our services, I'm in Missoula, but we serve the entire state. Because there's so few elder law attorneys in the state of Montana, a typical day for me is I might be working with someone in Eureka at 10 a.m. and at 1 p.m. I'm working with someone in Miles City. So, fortunate or unfortunately, however you want to view it, I bet over half of our clients I've never met in person, such as the family I was telling you about, the farmers. So my point is we got really good doing things remotely during COVID. And wherever you are, we can do this. We love to have you in the office, but if you don't want to drive 2 hours or longer, or you just want to do it from the comfort of your home, then we can serve you remotely. It's no problem. It's very simple to do. We can explain that process as well. So don't let distance be a factor. But most importantly, so if you have any questions, just sign up for the free consult, and we'll get in touch with you. Get something scheduled in the coming days or weeks, and we look forward to talking to you, answering your questions, and maybe even earning the honor of serving you and your family. Thank you.